Warning, censorship. Warning, censorship.
A little bit frustrated with respect to whether or not it was arbitrary. We really think that certain arguments were kind of ignored and others were given more emphasis, and so a little bit of our argument, I think, was overlooked.
So just to confirm, government lawyers were effectively saying that they're not detaining you, they're searching you for 3 days?
Essentially, yes, that was their argument. That wasn't a detention; it was an enhanced search by putting people into hotels, mandating that. It was, as I said, it was a little bit confusing about what they were actually arguing, because we were arguing Section 9, whether it was a detention. They were citing Section 8 case law, but that seemed to be what I took from it after the 3 days of hearing.
The idea that people should be forced to pay an inordinate fee to effectively be imprisoned in a hotel and served inadequate food, all in the name of health, makes no sense. It's unscientific, and worse still, it's a massive violation of our fundamental rights. Even if you were to believe that these measures might slow the spread of COVID, the fact that people exhibiting COVID symptoms are often sent home from the airport instead of being forced to stay in one of these COVID jails completely defeats the function of this program. It's troubling that no tourism agencies, human rights groups, or other business groups have challenged this problematic program. Only Rebel News and the Justice Center for Constitutional Freedoms have called out this madness. Rebel News hired 2 of the best constitutional lawyers in the country to challenge COVID jails in court. I'm going to be joined by one of them in just a moment for an update. But first, I want to thank you, because the fight for freedoms that we are waging is made possible by the contributions that you make at nocovidjails.com. We couldn't do it without you. Now, despite the clear lack of inherent logic in these COVID jail programs, Justice Paul Crampton of the federal court ruled against our appeal and in favor of the COVID jails. But this is not a fight we're willing to give up. We will appeal this ruling. I'm going to be joined now by the brilliant Sarah Miller of JSS Barristers for an update on the ruling and some details about the plan moving forward.
So we got our decision from the federal court regarding our judicial review application on the hotel quarantine. Unfortunately, Chief Justice Crampton denied that application, found in favor of the government on all the issues that we raised, including whether or not the detention was arbitrary under Section 7 or Section 9, and whether there was a reasonableness to the decision by the Governor and Council when they made the order under the Quarantine Act.
Okay, so and as we know, this is a ruling that we're going to fight back on, that we're gonna appeal. Is that correct?
Yes, absolutely. So we've gotten instructions to appeal. There's a number of issues that we want to appeal. We won't be appealing every issue. We want to make it a little bit narrower. So we'll be appealing the decision as for Section 7, Section 9, and with respect to the scope of the authority of the Governor and Council on the Quarantine Act. I believe. We haven't actually obviously filed anything. We only got the decision today, but that's where we're leaning towards.
So in lay terms, could you maybe lay down what those oppositions are, or what we're going to be appealing specifically?
Yes, absolutely. So Section 7 of the Charter gives everybody a right to life, liberty, and security of the person. And what we alleged was the being placed into quarantine into the government-authorized accommodations, the hotel quarantine, that is a diminution of your liberty rights. And so, we're allowed to go about, do our thing, whatever. In a pandemic, they've obviously restricted that by creating some of these 14-day quarantines. And then what we did argue was that then by placing everybody into a hotel when they arrive via airplane into Canada, that even restricts it even further. And so that is what we argued was impacted our Section 7 rights for liberty. Liberty rights are only impaired if those laws that impair our liberty rights are not done in accordance with what they call the principles of fundamental justice. So we argued that it wasn't within those principles of fundamental justice. It was arbitrary, it was overly broad, it was disproportionate. The judge disagreed with us, found that the matter did fall within the principles of fundamental justice and could be upheld on that basis. Section 9 of the Charter is arbitrary detention. So the government tried to argue that being put into a detention facility such as the government authorized accommodation was not a detention. And we argued that, yes, it was indeed a detention. So actually the judge did find in our favor as far as that goes. It certainly is a detention. There doesn't seem to be any dispute about that. The cases that the government was relying upon to say it wasn't a detention honestly had nothing to do with Section 9, had to do with Section 8, which is search and seizure law. When you're coming across a border. So they said, well, because you're coming across a border, you're exposed to greater searches, because, border crossings and security issues. And so that's not really a detention. They were kind of mixing the two, Section 8 and Section 9, and it really made no sense. So the judge did see through that, distinguished those cases and found in our favor as far as, yes, being put into a government authorized accommodation is a detention. Now, the second part of Section 9 is that detention arbitrary? And so we made a number of arguments that were rejected by Chief Justice that said it was arbitrary. He found, unfortunately, against us and said that it was not arbitrary, saying that there was enough of a connection between the Quarantine Act and what the intent of the Quarantine Act was and being put into a facility. So we're a little bit frustrated with respect to whether or not it was arbitrary. We really think that certain arguments were kind of ignored and others were given more emphasis, and so a little bit of our argument, I think, was overlooked.
So just to confirm, government lawyers were effectively saying that they're not detaining you, they're searching you for 3 days?
Essentially, yes, that was their argument. That it wasn't a detention, it was an enhanced search by putting people into hotels, mandating that. It was, as I said, it was a little bit confusing about what they were actually arguing, because we were arguing Section 9, whether it was a detention. They were citing Section 8 case law. But that seemed to be what I took from it after the 3 days of hearing.
And perhaps as a final note, I'm just trying to understand how they could argue, or how the justice could find that it's not arbitrary when people exhibiting symptoms have been sent to other locations. It's not being applied evenly across the country. Was there any explanation given for the verdict that it's not arbitrary?
So there was a little bit of suggestion. Mostly it came down, though, to the test. And the test that the court applied is a very difficult test to meet as applicants. He said, essentially, if there's any kind of residual connection, no matter how minor, between the law and the effect of the law, then that satisfies it. So he didn't really get into okay, well, I'm arriving in Canada via an airplane. I have symptoms. I'm going to be sent home. I don't have symptoms. I'm going to be sent to a GAA. But regardless of whether or not I get symptoms or test positive, I'm still being sent home at the end of the day. And so that was really our focus as to why it was arbitrary. At least, like, that was our intent of our focus, was to say, well, if you're somebody like Key and Bexy, who is our applicant, and you come into Canada via plane and you have no symptoms. It doesn't matter if he had tested positive or negative. He went to the GAA and then he was going to be sent home, regardless of whether he was positive or negative. And so that's what we were arguing was arbitrary. I think, frankly, on a plain reading of the word arbitrary, that it is arbitrary. But the judge didn't look at it in that pragmatic way. He applied a very strict legal test, which was, is there a connection here between what is being imposed, which is go to a quarantine facility, GAA facility, and wait, and is there, a quarantine reason, right? And so there's COVID-19 vaccine that wasn't really part of the case, so we weren't impugning that, and so that's what they found, is that there's a connection there.
Okay. So with this narrowing scope, with the appeal now, is the hope to look at specific cases and prove that these are indeed arbitrary?
Yeah, so again, it's very early days, so we haven't really laid out our whole argument and what, the exact things we're going to argue. Some of the things that I was talking about today in our office was Section 7 and incarcerated individuals. So if you're incarcerated and you're in facility that is a medium security facility, and you're moved to a maximum security facility, that can trigger your Section 7. And so similarly, if we look at quarantine, we're all going to be subject to this 14-day quarantine period. And this 3-day or up to 3-day hotel is comparable to that moving from a medium security to a maximum security prison. You're still under quarantine, you're still subject to certain provisions, but it's that additional little loss of liberty that really engages Section 7. So I think we're going to try and narrow in on that particularly, strengthen our arguments a bit, hopefully on Section 7 and Section 9, figure out ways to file the appeal, and then also hopefully get a court of appeal to decide on the scope of authority that a governor and council or the executive branch of government has really given in making opinions before they make laws.
Do we have a timeline for this yet, or is it just so early that we don't know yet?
So based on my read of the federal court rules, we have until September 20th to file our notice of appeal, and we have instructions to do that, so it'll just be, whether we want to do that sometime between now and September 20th. And then we'll be moving forward from there.
Wonderful. Well, thanks again, Sarah, for the wonderful update. If you want to continue following this story, go to nocovidjails.com. You can also make a contribution there to help keep up this legal fight. I want to thank Sarah Miller for always coming out and giving us an update straight from the courts. We really appreciate it. And I want to thank everyone for tuning in. For Rebel News, I'm Adam Soos.
We lost in the federal court today. A judge said these COVID jails at airports are legal. I disagree, so we're going to the Federal Court of Appeal. To read today's ruling and to help us fund our appeal, go to nocovidjails.com.